Okay, hello. My name is Christof Siefarth. I'm a partner with Görg in Cologne, Germany. I'm also admitted to the New York bar. I have some experience working in the United States as an attorney, and I have handled several 1782 cases, particularly for German clients, obtaining evidence in the U.S. for the use in, well, litigation cases in Germany. And Ed and I will try to highlight some of the points from the perspective of the attorney actually making the application, and I will more represent the user and raise some issues and particularly concentrate on how to introduce such evidence in our countries. I note that there are several Russian participants here. I would assume the application or the use of evidence in Russian courts or Russian arbitral tribunals and German courts and arbitral tribunals are very similar. So hopefully we'll cover this. Okay, thank you. Pat, you want to start?
I'm delighted to. So as I said, we're going to give sort of a background. I'll try to keep it high level because we want to talk about some more interesting parts of this. I'm going to assume that everybody watching this is interested in trying to get information through 1782. There are some people that think it's it's not a good thing, but I've handled both sides, so I've been on both sides of the issues. I've defended 1782s for clients where we think that there's been sort of an abuse of it, but I've done much more of actually prosecuting them and getting information for clients. So we do both sides, and there are obviously issues on both sides, but I think the one thing that Christof and I have come away from this is that no matter why you think it's a good idea or a bad idea, the reality is it exists. And just like in the United States, we have subpoenas and depositions, you need to know about this if you're doing litigation anywhere in the world or dispute resolution anywhere in the world. You need to know about 1782 because if there's evidence in the United States, at this point, it's so prevalent, the statute is being used so heavily that you really need to know about it as part of your, this is not some secret, this is something that you need to know and you need to use it when it's appropriate because it's something that's available and somebody look at you, why don't you use a 1782 to find out that information? So let me start the PowerPoint. There, oh, I went too fast. Really fast. All right, so what is 1782? Well, the statute has been around for quite a while, and it got active after a Supreme Court case called Intel, and up to that point had not been used a lot. But the key of the statute was the intent was to, if we allowed litigants in foreign countries to get information here, we thought that we would be able to get information easily in their countries. It hasn't really worked out that way, and so it's sort of a one-way street in a lot of ways. I mean, obviously, there's stuff we can get, and Christof could talk a little bit about that, but the reality is, I think the general consensus is that it's so much easier to get information here for a foreign proceeding than the other way around, and we are where we are, but this is what it is. And so this just talks about the elements. We're going to go through this pretty quickly. But the person has to reside or be found in the district, and so our courts are set up in circuits and then districts in each state of the country. And so when it says district, for example, I'm in the Southern District of Florida, which covers Miami, Fort Lauderdale, West Palm, if you know that area, and then Orlando, for example, where Disney World is the Middle District, and then Norman District, it's Pensacola. And so if you're looking for information, you'd have to figure out what district that entity is in or person. There's been a lot of litigation about that. It says testimony or statement, in other words, or produce a document. So what we're talking about there is we can take depositions, we can get testimony. Whether or not you can use that deposition or testimony in the case, in your case, is up to the court where your case is proceeding. But purposes of getting the information, you can use 1782 to get it. And then it has to be for a foreign international tribunal. And that there's some litigation about what that means, but clearly it does include any kind of civil proceeding you've ever thought of, administrative cases. We talk about criminal cases, and so it's a pretty broad statute. And so what we talk about here is how do you do it? So it really is an ex parte application. What I mean by that is that when you ask for a 1782, you're asking for permission from the court in order to get the information. And so you're going to the court and say, I want to say, take a deposition of this person who lives in, Miami. Once you get the approval, you don't have to tell anybody you're doing it. You just ask for the court. Then when you then get approval, you then take that notice, you give it to the person you're trying to depose, and then they have the right to say, well, this is an improper use of 1782, and there's a lot of arguments they could make. And there's always a possibility that your opponent in your case, so let's say it was a lawsuit in Germany, and you say you think there's a witness in Miami that's got information that's helpful. So Christof hires me, says I want to take the deposition of Mary who lives in Miami. I think she's got all this critical information, and for my case, it turns out that Mary says I don't know what this is going on, but she tells Christof's opponent what's going on. I've been asked to take a deposition. Well, Christof's opponent then can come in and intervene and say, hey, what's going on here? I want to be part of this. I will tell you my experience is it doesn't happen a lot. It does happen sometimes, but what happens more often is that you're able to get this information before people even know that you're asking for it.
Ed, we get the note, and that's right, chat. The slides do not change. Is that something you can influence? We just see the first screen.
Oh, I see. Oh, I was paused. I see. I apologize. Thank you.
Okay.
All right. Let me go back then.
Yeah, go back. One question in between. What do you see more, document production or deposition? You mentioned that you have the two possibilities. From my experience and from the experience of a user, we're more interested in document production because pretrial discovery is something we do not have, and it's particularly good to obtain documents which you would not gain otherwise. So what we usually do is go for document production first, and then if that's not sufficient, go for depositions. Is that also your experience?
I will say a couple answers to that. It really depends on what you're looking for. I think that, yes, the most common thing, I will say this. First, everybody asks for documents. So whether or not you are going to ask for a deposition as well, you're always going to ask for documents. A very common thing that people ask for are bank records, for example. In Miami, for example, we are sort of the center of a lot of Latin American banking, and so you see a lot of requests for bank records here, and those records kind of speak for themselves, and so you can use those elsewhere. You may or may not want to take a deposition. Now, there are a couple things about depositions. Whether or not the deposition is actually going to be used in your case is not what the courts look at. You may be taking that deposition just to find out where other documents are and that kind of thing. So it's not necessarily just an issue of, hey, I need testimony that I can use, and let's just use Christof as our hypothetical case. So it may be that he can't use a deposition he took in Miami in his case, but he might be able to find out information about where other people might have documents, or just find out information that he can use. The one thing we haven't talked about, which is pretty critical, is you can use 1782 before you even have filed your lawsuit or action in your foreign country. In other words, Christof can say, I am reasonably contemplating filing an action in Germany, and I want to find out if there's information that supports my case, and that is sufficient. That is sufficient to file a 1782 here in the United States. And I will tell you, this is the most ironical thing about this statute. I cannot do that domestically. I generally cannot, under U.S. law, file a action to discover information before I file a lawsuit. I'm supposed to file a lawsuit, then ask questions. This statute allows you to do, it gives you more power than I have domestically, which is a pretty cool thing.
Okay, thank you. Let's probably move on to the slide a little bit further on the number of actions we have. Your slide number 5. Yeah. Okay.
Yeah. So, right. And this is a couple of years old now, but what you're seeing here is that in New York, you're seeing a lot of actions, very common. The Ninth Circuit is California. There's a number of them there. The 11th is Miami area, like Florida, Alabama, Georgia. So you're seeing a lot in Atlanta and in Miami. Here's the DC Circuit. So this First Circuit, you see that's Boston area. So you see that the ones in the middle are less. So the big three have traditionally been New York, California, and Miami, but it's not, that's also some of the largest areas in the country as well. So we went through this really, and I'll go through these pretty quickly, and Christof will stop me if somebody has a question. We've talked a little bit about this already. You can get pre-suit discovery under 1782. I cannot generally do that domestically. I do it ex parte. In other words, I can get the discovery without the other side, Christof's opponent, not being there. I can't do that under domestic cases. If the court says, I'm not allowed, take the discovery, in a domestic case, I wouldn't be able to appeal that to the 11th Circuit here in Miami. I can do that in 1782. So if a trial court says, I'm not going to give you the 1782 discovery, you can appeal that to the appellate court, and there's a number of appeals that have come out of this 1782. So I'm going to now turn it over to Christof to talk about.
Yeah, that's a little bit, and there was John was one question about
okay.
if an arbitral tribunal is a foreign tribunal too. We'll come to that in a minute. When you use discovery and you use it for proceedings like in Russia or Germany, it's always the question how much you can use it, and isn't it a prohibited fishing expedition? And I have two examples here of courts in Germany who have decided not. It's generally acceptable. That's the German Federal Supreme Court who said that, and it does not violate public policy. And even the German Constitutional Court said that it's not a manifest violation of the indispensable principles of the rule of law. The interesting question is, how do you actually introduce evidence you have obtained in the United States through 1782 in proceedings abroad? It's pretty easy when it comes to documents. We attach documents to, or copies of documents to our briefs and thereby introduce them. We don't have to present originals. It may be different in China where you have to have certified copies of everything. A more tricky question is, what do you do with depositions? We do not have transcripts of depositions in the German proceedings. However, I have considered, I haven't done it yet, but I would probably do it. I would introduce a transcript of a deposition as a document, as a kind of proof that a witness has made the specific statements. One may consider asking this witness to testify again in the German or Russian or wherever court proceedings. So there are several possibilities. It's quite open. I've just done a search this morning. There's really nothing German courts or German commentators have mentioned in this regard, whether there are any limits to that. As long as we don't have to live with the fruit of the poisonous tree doctrine. So obtaining evidence in an illegal way results in not being able to use the evidence. I mean, you're free. And that, as I understand, applies to many other countries too. So Ed, I think it's your turn again.
Okay, yeah, so now I'm just going to talk about the basic elements of a 1782, and we'll get to the answer to your question very shortly by answering these questions. Okay, first off, that we talked about, the target must be found in the district. I'm actually author of a co-editor of a treatise on 1782, and I wrote a chapter in our book with my wife, who's a law professor. And our chapter has to do with found in the district. You would think this would be a pretty simple question. It's not. There's been a lot of litigation of it, but just a couple of thoughts on it. First, being found in the district, if you get subpoenaed, in other words, they get service over you while you're in Miami, you could be required to come back and take a deposition. There's been case law that supports this. I think it's crazy, but it goes back to the fact that in the United States, we have a thing called gotcha jurisdiction, which is if you get service over somebody and they're visiting our state, and whether it's a lawsuit or subpoena, they've got you. And so they've held that you've been found in the district if you get that. The other big fight is corporations. So where are they? So not to belabor it, but there's been a lot of litigation over that. But generally what you're seeing is because the circuits are differing on some of the elements of 1782, there's been a lot of forum shopping as to where to file a 1782. And so it is important to hire a lawyer in the United States that has done this before, that can help you figure out the right place, because there could be multiple districts where a corporation is found. It doesn't necessarily have to be their main headquarters. They can be found in other places, and you may make a strategic decision that you want to sue them in a district that has more favorable law. And so you need to make sure you understand the differences of what. Don't assume that U.S. law is consistent, because it's not. The courts have interpreted the statute differently. It's got to be for use in a proceeding. That's pretty easy. It basically, has to be, used. The only issue there is there's been some litigation as what happens if the lawsuit is already over. Can you use it for post-judgment recovery? And so, but if it's a pending or a future proceeding, it's not an issue. There is litigation about whether or not you can use it to collect a judgment. That's a whole other area of law, but generally that's a pretty easy element. This is a question that somebody had. What is a foreign tribunal? We'll have a slide in that in a second. We'll go in more detail. And you have to be an interested person. And basically an interested person it does not necessarily have to be Christof's former client. So use Christof as an example. He's got a lawsuit for a corporation, and the corporation says, hey, I want to, get information in Miami, and it's owned by, Mary Jones, who's 100% owner. Well, the corporation who is Christof's client could be the petitioner, but it also could be Mary Jones, the owner, because she's deemed to be an interested person. So it does not necessarily have to be the person. So we talked a little bit about this already. This is the found in the district issue, and here I'm talking more about corporations. And what you're seeing here is that you can get a corporation that has continuous and systematic contacts in the district. The gotcha jurisdiction I mentioned earlier, that is getting a person who's actually here on vacation. And specific jurisdiction, what I mean by that is there are courts, specifically New York, that have said that if you have a target, let's use Christof's example. Let's say Christof thinks there are bank records in New York, but the bank is actually based in California, but he wants to go to New York. But he thinks that they're doing business, that the target he wants is doing banking activity in New York because they opened the account there. And that, so what he would argue is, well, I want the bank records in New York, and the bank, although it's based in California, the bank records are actually in New York, and that's where the account was open. And so the genesis of the dispute for purposes of 1782 is in New York, and he may decide I want to go to New York over some other place. And so it really it does go into, again, talking to somebody who knows what they're doing and knows the area.
And let me probably shortly mention the case I mentioned there. Maybe in the meantime, I think my picture isn't shown. I think you should release me, and then people can see me too. Something you can. So there are two cases while I'm talking. It's mentioned here in Gemeinschaftspraxis Dr. Machotov, of course, in New York. And that was interesting. There were some proceedings of some physicians in Germany before social courts, and they wanted to have some proceedings in order to get more money from the Social Security authorities. And they knew that McKinsey Germany conducted a survey, and they hoped that they would have some figures in their favor. So they filed this application in New York, as Ed mentioned, Second Circuit. And the New York court, SDNY, ordered McKinsey New York to more or less request from McKinsey Germany to produce the document via McKinsey New York, and then it would go back to Germany. A similar case, since this is very much about Russia, was decided, interestingly, by the Northern District of Georgia in 2013, involved some famous divorce proceedings between Sergieva and Anna Sergieva and Mikhail Dubin, the former wife of the very rich Russian person, was seeking some documents regarding marital assets. And there was a company in Atlanta, Georgia, who had some of the documents, but there were also some documents, I think, on the British Virgin Islands, on the Bahamas. And exactly, they used the fact that this company was based in Atlanta, but could ask some of its subsidiaries for documents abroad. So that is something which is very helpful. 1782 is pretty broad as discovery generally, but this is even broader. You have to find a link to the United States. That's it, as Ed mentioned. But without that, it wouldn't be possible. There were some cases also involving Russian parties where there was no one where the district court in the United States had jurisdiction over. And that would not be sufficient. I assume, Ed, you had some cases in this regard too, where the court found there was no jurisdiction over the person, so they could not enforce that some documents which were located elsewhere, or where the party from whom the documents were requested did not reside in the district of the court. Seems to be a common issue.
Yeah, so what I've seen, and I've been trying to get Christof's beautiful picture here, but unfortunately I'm not technically able to do it. But rest assured, Christof's a great looking guy.
How it works. Okay.
What I have seen is, for example, we had a bank client, and they really, the other side wanted to get advantage of favorable 11th Circuit law, so they were trying to make the argument that this bank account that was opened in New York and actually had to do with a German proceeding. It wasn't Christof's client, but it was a German proceeding, and we were defending the bank. And our position was that there really was no connection in Florida, and their argument was, well, you're a big bank and you got branches in Florida, and our point was that it has nothing to do with what you're looking for. The bank account at issue has nothing to do with Florida. It was open in New York, and we're based in New York, and they backed away. And so you are seeing, this is a perfect example, you're seeing forum shopping depending on frankly, 11th Circuit where I live, Miami, is the most favorable pro 1782 district or area, if you will. The law has been very favorable, been very open to 1782 compared to other districts. And one issue which we're about to get to, let's see here. And so, which goes to the question we had in our chat. So the first is the easy one. What is a foreign tribunal? And this is, clear. And so the foreign tribunals have easily been investor state tribunals. Clearly, you see there NAFTA, use of trial, any civil, commercial, probate, bankruptcy, criminal, family law, administrative courts. And so the question we have on the panel here was about private arbitrations. And so we actually have the answer to that for you. So there's a split of authority on this issue. Historically, what happened was, I mentioned the Intel case earlier, and the Second and the Fifth Circuit, you see where they say no, had previously, before Intel, said that it did not apply to private arbitrations. And so the concept is that they believed, based on their research of the law, that 1782 was only to support a court proceeding, okay, and not, or a government proceeding. And so a investor state arbitration would qualify because the state's involved. But if it's just between X company and Y company, and it's a private arbitration, they did not believe it fell within foreign tribunal. Then Intel came out, And Intel interpreted tribunal pretty broadly. And then, so after that, the first case that dealt with it was 11th Circuit. It was actually my case against Glenn Hendricks, who I think you've met. And Glenn and I litigated this issue in the 11th Circuit. And in that case, originally the 11th Circuit in Consortium said that it did apply to private arbitration. And then my friend Glenn there moved for rehearing, and they changed their mind and said, well, we don't think we need to deal with that because there's a pending lawsuit. And so we're just gonna, not answer the question. So the first answer to the question was, we don't know yet. And then the Fourth and the Sixth Circuit have said yes. And the difference is then the Second and Fifth after Intel have said no. And the reason why is the Second and Fifth have said, well, we had already said that it did not apply to private arbitration, and we don't think Intel is strong enough to tell us that we were wrong. The Fourth and Sixth were not bound by prior precedent, and so they looked at Intel afresh and they said, well, we think it's pretty clear, but the Supreme Court is saying it should apply. So this is very important because the Fourth and the Sixth, you're talking about the Midwest, Ohio area, the Midwest of the United States. Second is New York. Fifth is Texas area. The 11th is Florida, Atlanta, Miami, Atlanta, that area. So you see that you're getting different answers depending on where this information is. And if you have choices and you think that you want to make this argument, you might want to go somewhere where they've answered the question in your favor. If you're defending one of these, let's say you're trying to stop this and you want to intervene, you want to make sure it's in a place where they've said no. So we do have a question, and I think it's timely now. They said, well, first question was, does it apply to private arbitration? The answer is it depends on where you are. The second question is, when do we go? Do we wait till the tribunal is constituted? When do we ask? And so here's the deal, and then they said, when do you inform the arbitral tribunal? So this is, the practical part of this, which is really important for this panel. We're not just talking about the law, we're talking about the practicalities of this. And on the practicality of it is, the first thing we mentioned to you is you can file for these before you even filed the arbitration. And it's one of those things that, they used to tell you when you were a kid, you're better off asking forgiveness, instead of permission. So, go ahead and get it. And then if you can't use it, too bad. But if you ask somebody, can I do this? The tribunal may say no, and then you're stuck. And so one of the things we look at, we've talked about this.
Add one question in between. So if we can't be sure, let's say we go to the 11th Circuit, your area, Atlanta. Shouldn't we try to avoid that comes in connection with an arbitral proceedings? So, for example, is it possible, in Germany it's quite easy to file a criminal complaint, and then you have some criminal investigations, how we call them. Would that be sufficient? So if there's no arbitration, shouldn't you try to install some other possibility? So how about, for example, criminal investigations? Is that sufficient to obtain a 1782 degree?
The answer is yes. And it's funny you should mention that, Christof, because that's exactly the fact scenario in Consortium. That's exactly what happened. What happened in Consortium is we were the applicants, and we had an arbitration going, and we were going as a subsidiary, which is something you need to think about. We were going after the subsidiary of the company that we were in arbitration against. And my partner was handling it. I got involved later on appeal, but my partner, smart, Jose Azaraga, I don't know if you met him, he was thinking, well, wait a minute, the law wasn't clear whether or not it applied to international arbitration. And so he said, okay, I have this pending arbitration, okay, but I'm thinking about filing a lawsuit, against these two former employees. So what happens is these two former employees had left the company, our client, and they were now, working with the other side. And so we said we wanted to find out information because we may want to sue them. And so what we decided that we would argue both, just like Christof said. And so what we basically said is, yes, we have this contemplated lawsuit, but also we have this arbitration. The trial judge took the lawsuit. Then it goes up on appeal. The appellate court used the arbitration. The judge, Marcus, was really interested in that. He wrote a long opinion about how it applied to private arbitrations. And then in a footnote, they said, well, by the way, we also have this lawsuit. So then Mr. Hendricks, who's our host today, moved for rehearing, and then we don't get a chance to respond. And then on rehearing, the court switched its analysis, took the information in the footnote, put it into the text, and said, we're going to use a lawsuit, just like the trial judge. And then the footnote says we don't have to deal with the arbitration issue now because we should only deal with issues that are clearly before us. We don't need to reach the arbitration because, just like Christof said, we have this alternative. And so the court decided to use a lawsuit that had not even been filed. So Christof has a really brilliant idea there. If you are in a place where you do not have a law that allows you to file because it's an arbitration, do you have another proceeding? Is it a criminal proceeding? Is it a court case against someone else? I will say to you to be careful that courts will see this as game playing. If you if it's pretty clear you're trying to circumvent, be careful of not being obvious about what you're doing, because there are discretionary factors, which we'll get to in a moment.
Okay, there's one question, Ed, if I may interrupt. A very interesting question from Asana Wright. Would ICC with a seat in the US be considered a foreign tribunal in the Fourth, Sixth Circuit under 1782? I would assume it's not, because it doesn't matter whether that the ICC is in Paris, but it would be considered US arbitration with a seat in the United States. And this arbitral tribunal wouldn't be considered a foreign tribunal.
Yeah, I do. I will say the following. In the 11th Circuit, they have interpreted any arbitration that involves foreign parties to be governed by the New York Convention. So I think there is an argument, which I don't know if it's been accepted, but if you were desperate and you had no other argument, I think there may be an argument in the 11th Circuit to say that even a tribunal seated in the United States is still a foreign tribunal for purposes of 1782, because the 11th Circuit has interpreted any international arbitration seated in the United States or elsewhere to be a foreign tribunal. That is not the majority rule. Most courts have said the opposite. For example, in New York, just like, so if you have you have a award that was entered in New York, it's a New York Convention case, but at the end of the day, it turned out that the seat was in the United States. Under New York's analysis, they would say that the grounds to vacate that award are U.S. law, not the New York Convention, because it's seated in the United States. And so there's a split of authority on that issue right now. But so again, I think it's aggressive. I don't think any court that I'm sitting here right now I can think of has addressed that issue. But I do think that the right analysis is likely to be, as Christof said, it's not a foreign tribunal. It is. So we were talking about what a tribunal is. You're now talking about, is it really foreign? Because it's here, not somewhere else. So I think the better argument probably would be that it's not foreign. It's a tribunal in the fourth and sixth, but it's not foreign.
Okay, Glenn Hendricks wanted to ask to say something on that. Glenn, can you speak? Okay, please.
Yeah, there actually is a case in California, as I recall. I believe it was the Northern District of California. They rejected that argument. But I agree with Ed, it probably would not work, but the argument would be it's an international tribunal. And even in circuits outside the 11th, like in New York, they consider a international arbitration seated in the US as what they call a non-domestic arbitration. The difference between circuits comes at the enforcement stage. So, prior to enforcement, when you're looking at whether 1782 applies, even the Second Circuit, New York, et cetera, would consider it a non-domestic arbitration. So I think it's an argument that you could make anywhere, but you'd be really pushing the envelope on 1782. And the one time I'm aware of that it was tried, in this case in California, it didn't work. But I think
And what Glenn's going to is that the standard is foreign or international tribunal. So
Exactly. So it's not foreign, but it's international, would be the argument.
Right.
Right. That's interesting.
Okay. Thank you very much.
Let me go back to where we're at. We do have a question, so let me get that question answered before we move on. This is where we were at. Okay, so the question is, okay, to add practical comments, but what if the need to file the 1782 application for whatever reason comes up only after the tribunal has been constituted? Would you knock the tribunal's door seeking permission, or do you still file a 1782 up front? In other words, so the question is, okay, it's very easy to say, yes, we should do this beforehand, but what if I don't have that opportunity? What if I already have a tribunal? I came up with this brilliant idea after the tribunal is already, goes in. Am I better to ask permission, or should I ask forgiveness? Well, I will say the following: you don't have to ask. So the law is that I do not have to ask. What I am seeing, and I think we have Glenn here as an expert on this as well, and I'd like to have his thoughts. But what I am seeing more and more often are that people are much more savvy to 1782, and they are putting up front and putting in procedural orders. You're not going to do this, and you don't want this. But the easiest way to kill a 1782 that for a tribunal that's already in place is you must, basically in order to meet the factors that you need to meet, you need to show that the tribunal said no. And it's got to be specific. We don't want this. Not only do we not want this, we're not going to look at it. And not only that, we don't want you to do it. A lot of tribunals are very reluctant to say that. But so certainly the other side, if you bring it up, that's certainly where it's going to go. But but one thing you need to realize, that if you go get something and somebody thinks that you're playing games with your tribunal, you need to really think about, how you feel with your own tribunal as to whether or not how they're going to react. I will say that generally, at least under U.S. law, you are not required to do it. But I open the floor to my colleagues, including Glenn, who's really knowledgeable, to see if you guys have a different opinion to that answer, to that question.
Ed, there was a question to that too. Someone agrees with you, but what if the need to file the 1782 application for whatever reason comes up only after the arbitral tribunal has been constituted?
Well, that's my point.
Mentioned that. Would you knock at the arbitration tribunal's door seeking permission, or would you still file the 1782?
Yeah, so, right. So my answer to that is that it's not, so the answer, and this is probably not, this is what I should do. I think the answer is more driven by your own knowledge of your own tribunal. Under the law, you do not need to do that. Under U.S. law, under 1782 law, you do not have to ask permission. You need to decide whether or not you think it's a good idea vis-a-vis your tribunal.
And that's a practical consideration, from Europe or from civil law countries. Usually it's not advisable to ask an European arbitral tribunal or a court to intervene there. Rather, you should do it without the court, because the court may not know this. I mean, the civil law court or the arbitral tribunal, and they may explicitly state that they do not want that, and then you're in trouble in the United States. So my suggestion in other scenarios would be not to seek permission, but go ahead with 1782.
Yeah, so we've been
But thank you for the question,
Yeah, so we've been jumping around, which is all good. Here's another question. So if you limit the scope of discovery during preliminary hearing in arbitration, you can limit the scope of discovery under 1782. So again, what I have seen, again, I open the questions up to Glenn if he has any thoughts on this. But what I have seen is that more and more often, you're seeing opponents, who may know that there may be for evidence in the United States, put in the terms of reference, put in the preliminary hearing information. Hey, you're not going to go get 1782, and if you are, you got to ask permission. Somebody, yes, if you may be on the other side and you want to do that. Say, look, you may be getting the ideas the other side they didn't have. On the other hand, they don't have to ask permission. So that they can go get it. And, so you need to think about that, depending on which side you're on. And do you think that your side might have bad discovery in the United States that you don't want people to see? You might want to go to the tribunal and stop it before it goes too far. On the other hand, you may be somebody that, the other side's got information, got a subsidiary, it's got all the goods, they're not turning over documents, and you want to get that information before the tribunal says no. So again, it really depends on which side you're on, and knowing your case and knowing what's there. The life lesson out of this panel is you need to know this and have this in your analysis, and not just, I would never do this. Well, is your other side going to do this? Especially if there are Americans on the other side that you're defending against, they're going to think about this, and you need to have this in your head. So we have a lot of panels. We've covered a lot of issues, but let me just get through this. Please feel free to ask any questions. We've already talked about this. This is, it has to be reasonable contemplation. The only thing I would add to this, focus on, is that, it's got to be more of a twinkle in the counsel's eye. In other words, if you think you're going to, ask this before you file, what you normally would want to do is have an affidavit of a lawyer in that country. So these are the elements of the cause of action. This is the kind of evidence we would need. Often, as you guys know more than I would, in a civil country, you've got to have your ducks in a row before you file. And so it's very easy to show a court that, I need this information in order to meet my obligations, in my foreign country, my home country, because they require us to, have a lot more information than you guys do. And so I need this. And if you have that kind of affidavit, it's going to be a lot harder for the trial judge here in the United States to say, well, I'm going to turn this down, because it's just, you're just, fishing.
In all the cases I have handled, in all the cases involving Germany, I read, there was never the issue, or there was the issue, whether the court, usually the German court, would be interested in that. But there was never an explicit statement of the court. So that is very rare. And my suggestion is not to ask the court and not to assume everything by the court. And you're right, if this is a possibility to obtain evidence, the German court wouldn't understand 1782 anyhow, not. And then just go ahead and don't do this. If I'm on the other side, I would rather invoke the argument that discovery is contrary to our system. The same may apply to Russian applicants, and probably ask the court for a specific statement that the court is not interested in such evidence. Would that be something the U.S. court would use in its discretion to dismiss an application? What do you think, Ed?
Yeah, so I'm going to ask that question, but I want to make sure we're trying to follow the slides a little bit. So what you were just talking about is right here on this slide. The courts do not require you to go to the tribunal first. So there's a quote from one of the cases. So that's the law in the United States. So let me pull up the answer to your next question. This is an interested person, so we talked about that already. Let me pull up the, so this is the question that I was just asked by Christof, what are the elements of 1782 beyond the statutory elements? So we spent a lot of time already talking about what are the requirements. You have to be a foreign tribunal, international or foreign tribunal. You have to be for use. It's got to be discovery evidence. You got to be found in the district. So those are the statutory elements. You got your order. You get a subpoena. You go subpoena the company or the person. It's okay, I now want it. Now the other side can come in, and so they can argue first, well, you didn't meet one of these elements, but those are pretty easy to meet in a lot of cases, especially if you don't have this arbitration issue. So then the litigation, a lot of the litigation goes to Christof's question is, are there discretionary? So you do not have a right to 1782 discovery. It is discretionary. And the Intel court had basically set out factors that we look at, the courts look at, that the court can use in its discretion to say, yes, you've met the statutory elements, but we think in our discretion, we're going to say you're not entitled to that. And for example, in the Third and Fifth Circuit, if that tribunal has said, no, we do not want this, those courts have said, okay, we're not gonna let you do this, and so on its discretion. The First Circuit has talked about authoritative proof. If there is a controlling Supreme Court case in Germany that says we will not take 1782 discovery, then you could have the court in its discretion say, you've met the statutory elements, but you can't use it. So I'm going to discretion saying this is a waste of time. You're wasting the time of the third party. You can't use it for, bad faith. You can't use it you can't be burdensome or unreasonable. The other, and these are the formal discretionary factors that we talked about. We talked about some of the general ones, but these are the 4 that the Intel court pointed out. These are some very important factors you need to know. First off, the party cannot be a participant in the foreign proceeding. In other words, let's use Christof's case. It turns out that Christof has an arbitration in Germany. It's against ABC Company. ABC Company is based in Florida. He wants to go a 1782 to get discovery in the case here for his arbitration that's seated in Germany against ABC Corporation. ABC Corporation say, no, I'm in that arbitration. If Christof wants stuff, he can ask me there. He can't go here and use 1782 to get something against a participant. Now, here's the trick. Does that apply to subsidiaries, affiliates? And what you see is, oh, no, I'm suing ABC, the parent corporation, in the arbitration. I'm asking ABC Florida, the subsidiary that's wholly owned, but I want their documents. And you know what? It turns out ABC Florida has the ability to push a button and they can get information from Germany. And so then they say, and this is actually true law in the 11th Circuit, if they have possession, custody, control, the ability to get information from a foreign country here in the United States, you could require them to bring it in here and get that information. So it ends up being sort of like a circular argument, but that's where the litigation is going. So there's a lot of litigation where people are being very creative and say, well, no, I'm not going against the company I'm actually involved with in the arbitration. I'm going after some entity that's here.
And actually all cases I have handled 1782, and there were quite some, I applied your advice to all of them. So that is very helpful. We have 2 more minutes, and I put everyone like on the screen here. So I think if we have any questions, you may actually pose it. You just have to unmute yourself. So are there any final questions? Because I think we have just 2 more minutes, and we should people give a chance to ask any more questions.
And the last, I want to focus on factor 3 before we open it up. If it looks like you're trying to circumvent, what's going on. So to use my example, even if you go after a subsidiary, you would go, the other side would argue factor 3 that you're trying to get around limitations in the arbitration itself. But if anyone has any questions, either talk or just put a question and answer in the box.
Yeah. One comment on that, I looked at some Russian cases, and they were quite recently. They were like in the last 10 years or so. And it seems to be that some political issues were mentioned here. So some applications for 1782 were dismissed because of, one could say political issues. So there was a case involving U.S.C oil. There was a case with the Russian Deposit Insurance Agency. So that is something you should be very cautious when you're involved with. And I'm not talking about politics right now, but that is an issue. So the courts use their discretion in quite a way, and they always find a way out. There seems to be more dismissals than actual denial of cases.
So
I think time is off. Yeah.
We've been brilliant. No one has any questions because we've been so comprehensive, or everybody's really shy, or more likely that my technological limitations have prevented them from asking questions. But
well, we had some questions in between. I think it was great, and the number of participants even increased during our session.
I
so
know.
That was very good.
That is very
Thank
good.
you all, as we say in the South.
Yes.
Thank you, Ed. I think we're through.
We are.
And that was a pleasure, and I hope we can do it again one time.
Yes. Well, thank you very much, everybody. It was really a lot of fun. And if you have any questions, feel free to reach out to either Christof or I directly. And we would like to answer your questions offline.
Thank you very much. Talk to you next time.
Bye.
Bye.